theory to practical problems of policy implementation. And I can say from personal experience that as a scholar, he has an unusual generosity of spirit, showing real interest in lifting up the work of others. All of these aspects of Professor Pidot's career are laudable, but what makes me so excited to hear from him today is that his perspectives on environmental law and policy benefit from a long and distinguished record of government service. Professor Pidot served as the Deputy Solicitor for Land Resources for the Department of Interior during the Obama administration. He was also an appellate litigator at the Environment and Natural Resources Division of the U.S. Department of Justice. And most recently, until June, he served as General Counsel at the White House Council on Environmental Quality. I would count myself in roughly the same generation of environmental lawyers as Professor Pidot. Our generation of environmental lawyers inherited the founding suite of federal environmental statutes that continue to define domestic environmental law, from the National Environmental Policy Act to the Clean Air Act. Here at PACE, we have the honor of working with many who helped to birth those laws: Professor Nick Robinson, Dean Emeritus Richard Ottinger, Emeritus Professor Jeff Miller. But our generation of environmental lawyers came of age in a time of political gridlock on the environment. Environmental law and policy became about making do, squeezing the most progress possible out of that original suite of environmental statutes, fighting to fend off efforts to roll back environmental protections, and searching for legal levers to require action on climate change in the absence of the political will to do so legislatively. What makes Professor Pidot's recent government experience so compelling is that in his time at CEQ, he was, and I've gone back and forth about whether to say at the table or presided over, maybe you can tell us, the most significant developments in environmental law and policy in my professional lifetime. As one example, Professor Pidot was general counsel at CEQ during a period when significant changes were made to the United States signature environmental law, the National Environmental Policy Act, and its implementing regulations. The first time really that had happened since 1970 and 1978, respectively. NEPA requires environmental review for federal action and ushered in principles of environmental review that have been adopted around the world. And CEQ, where Professor Pidot served as general counsel, is the agency in the executive office of the president that oversees implementation of NEPA. Congress significantly amended NEPA through the Fiscal Responsibility Act of 2023, and CEQ released new regulations for implementing NEPA in 2022 and 24 with Professor Pidot at the helm. I will share that being on the outside looking in during this process of NEPA reform, and I think I can say fairly, the students in my environmental survey class experienced no small amount of anxiety. NEPA has been so central to environmental protection in the United States that one must fight the immediate response when the subject of NEPA reform comes up of, don't touch a hair on its precious head. But I would frequently tell myself and the anxious students in my class that we couldn't be in better hands because NEPA's general counsel was a top-notch lawyer, scholar, and policy wonk. So Professor Pidot, in addition to extending a welcome to Pace Law School and a congratulations on the Kerlin honor, I want to also thank you for your service at CEQ, which helped me and my students sleep at night.
Move the microphone up a few feet again. The clicker is not working. There we go. So, got to click through all these amazing photographs of Professor Pidot, so we'll have to get through this, right? So, somebody who cares a lot about our natural environment. And at this time, I'm delighted to present the 2024 Gilbert and Sarah Kerlin Lecture Award to Professor Pidot. Now you may come up. Congratulations. I'm going to take one step to the left. Great. This medal, which you have before you and everyone else sees on the screen, displays a topographical depiction of Storm King Mountain, paying homage to a ruling that that helped inaugurate what today we call environmental law. This topographical rendering of Storm King also serves as the logo of environmental law, our environmental law program. And on the back of the award, your name is inscribed. And so now you finally get to take the stage and deliver the 2024 Gilbert and Sarah Kerlin Lecture on Environmental Law. Justin, the floor is yours.
Somewhat unusual for me to have to lower the microphone after someone. So thank you, Jason. Thanks, Katie. Thanks to all of you for being here and to Pace for the invitation. There we go. I just wanted to make sure I knew which slide we were on. As you can imagine, it's a somewhat odd day to talk about environmental justice at the White House. When Jason invited me, I didn't know, and when I read this slide deck and prepared my remarks, I didn't know exactly how I was going to introduce it. The initiatives I'll be focusing on are largely derivative of the president's authorities and President Biden's commitments. They are very likely to be undone in the next administration. And so we're, in some sense, looking retrospectively. It's not quite the end, but at what the Biden administration emphasized from the perspective of the White House in the environmental justice space. For those of you who are taking administrative law or interested in administrative law, there are some features of presidential action which make them particularly likely to be changed, reversed, undone. In part, it's the profile, of course. When the president acts, there's just a stature to those actions that highlight them when there's a change in administration. Certainly, we saw that in the last Trump administration. We saw that in the Biden administration. And I think one can anticipate seeing it again. There's also very little process that's required. Many of the programs I'm going to discuss flow from executive orders, and executive orders, unlike, say, regulations and the like, don't have any procedural requirements that go along with them. Right, the president is not an agency. He's not subject to the Administrative Procedure Act. There's no notice and comment process. The next president can, on day one, revoke any executive order he should so choose. I'll put a little footnote there. There may be some difference with national monument proclamations, which I'm going to touch upon towards the end. But when it comes to sort of the mainstay executive orders and the programs that flow from them, as someone who's spent the last 3.5 years on these programs, along with a NEPA reform and a number of other priorities, it can be hard to imagine our work being swept away. Although I was in the Obama administration at the Department of Interior when President Trump came in, and so have gotten to go through this once before. I will say that the last experience gives me a perspective that is not just pessimistic, but also infused with optimism. And in two ways. First, some of the programs I'll be talking about were and are focused on delivering resources and benefits to communities that have been left behind, communities that are disproportionately burdened by pollution and have received a disproportionately low amount of federal, state, and other investments. We, in the Biden administration and the president and the agencies, have made substantial investments in those communities over the last 4 years, and that means real benefits for people across America. And that can't be undone. Second, it's much easier to restore things than to create new programs. So the work that we've done, if there is a change in administration, or a change in political temperament down the road, and I believe there will be, as we've seen in the past, these programs will be resources that can be drawn upon. The work we did, the problem solving we did, the challenges that we encountered, those are all lessons that a future administration can learn. Ooh. But let me back up. I'm going to start with two questions. First, what is environmental justice? And then what is the White House? You'll see why in a few minutes. But what is environmental justice? Environmental justice is a sort of a vocabulary came into sort of public consciousness in large part with a Church of Christ study. Sorry, this is the wrong slide. Should be here. A Church of Christ study from 1987 called Toxic Waste and Race in the United States. In that study, and here's just one map of Atlanta, Georgia from that study, found that, and it was focused on hazardous waste dumps, so generally RCRA permitted facilities, and found that they were concentrated disproportionately in communities of color and low-income communities. As this map, probably a little hard to read, but trust me that the numbers would back that up. And there's a bunch of statistics in it if you care to read the report. In 2007, the Church of Christ did a update, Toxic Waste and Race at 20, which again found that people of color in particular, even more so than low-income individuals, are where these facilities exist and often where they're clustered. So that's what that data shows. So this is sort of the first instantiation of environmental justice in the federal government, really is traceable to that work. And this is in EO 12898, which was President Clinton's executive order on environmental justice. And it focused on disproportionately high and adverse human health or environmental effects on minority populations and low-income populations. This here is a map from another tool that we'll discuss that tries to track disproportionate burdens. But very much about what is the distribution of environmental harms across the United States. But since that time, our concept of environmental justice at the federal level has expanded. So another question people ask, what is the distribution of environmental benefits? So these are a map on one side and some data on the other about the communities that have less access to nature, whether it's parks, wildlands, and otherwise. And so this research shows that, and the phrase that government loves to come up with phrases that are hard to say and a little impenetrable, but nature-deprived communities is the phrase that we use. And so the data indicates that nature-deprived communities also are disproportionately low-income, disproportionately communities of color. And there's a third facet of environmental justice, a procedural facet. And so this here is not actually a picture of the Gulf Link oil export terminal because it's still in its proposed state, but effectively what it would look like. It's a deep water, proposed deep water port off the Gulf of Texas, or off of the Gulf Coast in Texas. And at capacity, when and if it's completed, we'll export 1 million barrels plus of oil a day and 157 new miles of new pipeline. There was an environmental impact statement that was completed at the end of the last Trump administration, and a complaint that I think we took very seriously was that there was no effort to translate any portion of the EIS or facilitate limited English proficiency individuals participating. This map on the left shows that there's the prevalence of the low English proficiency individuals in this area. It's about, I think, 16% in Matagorda County and around just under 10% in Brazoria County. So another form of of environmental justice is this procedural dimension that I think we took seriously and has become part of the way that many environmental justice advocates think of it. So Executive Order 14096, this is President Biden's sort of signature environmental justice executive order, built on what you saw in 12898 a moment ago, to describe environmental justice as meaning just treatment and meaningful involvement of all people, regardless of income, race, color, national origin, tribal affiliation, or disability. So you see there both an expansion of the categories that are being contemplated, also a shifting of the approach. If you remember in the Clinton executive order, it was specifically focused on low-income communities and communities of color. Here, the president's executive order really tracks a lot of signature civil rights laws rather than focusing on particular demographics, focusing on the denial of just treatment and meaningful involvement on the basis of race or these other categories. We see that environmental justice means protection from disproportionate and adverse human health and environmental effects, including risks and hazards, including those related to some of the critical challenges of our time, like climate change. So that notion of avoiding or addressing the disproportionate environmental harms, but also equitable access to a healthy, sustainable, and resilient environment, right? Focusing on the benefits, not just the harms. And finally, environmental justice means consulting with tribal nations on a nation-to-nation basis. Really a substantially expanded and much longer executive order. So if you care to read it, it has a lot of text in there. So what is the White House? Well, this is the easy answer. It's the president. It's this building. Again, you'll see why I posed the question in a moment. The president here has been active in this space. Two executive orders in particular, Executive Order 14008, which was the executive order on climate that President Biden issued on the day 7 of the administration, includes an environmental justice component that is headlined with this commitment: we must deliver environmental justice in communities all across America. And that executive order created these programs, the Justice 40 Initiative, a screening tool, a scorecard, and then 2 advisory bodies, which I'm going to talk about in a little bit more detail. Then 2 years later, Executive Order 14096, which I just mentioned, on revitalizing our nation's commitment to environmental justice, included additional programs, set in motion a government-wide approach to environmental justice, directed agencies to develop strategic plans around environmental justice, set in motion an environmental justice science data and research planning process to identify the gaps in our knowledge that themselves can shape the way that environmental harms are distributed and do not reveal fully the effects the communities experience, and then establishing a White House Office of Environmental Justice. But there's a lot of other executive orders that also addressed environmental justice. I'm not going to go through these, obviously, all of them in turn. I will note, since I am back in the academy and thinking about teaching, executive orders, probably relatively familiar to all of you. EOs is what we refer to them. The abbreviation PM may be less familiar. It stands for Presidential Memorandum. It is effectively very similar to an executive order. The Office of Legal Counsel at the Department of Justice has in fact said that a PM and an EO are identical, except for one thing, that only an executive order can modify an executive order. A PM cannot modify an executive order. They tend to be written when the directive is toward a fewer number of agencies. So rather than a lot of executive orders cut across a great number of executive branch agencies. The other things I would just note here, you see environmental justice in the way that the president wanted to implement the bipartisan infrastructure law, the Inflation Reduction Act. So you see the executive orders around those capturing environmental justice. Again, you see tribal consultation and self-determination layered into some of these executive orders. And then even in executive orders that might seem far afield, like on strengthening American leadership in clean cars and trucks, I think the president recognized that as we build electric vehicle charging stations and other EV infrastructure, without attention, communities that often are excluded from government benefits will again be excluded from government benefits. And so if we want an equitable transition, we need to pay attention and ensure that all communities enjoy the benefits of the federal investments that were being made under the bipartisan infrastructure law. Back to what is the White House. So there's 3 other buildings, at least, that make up the White House complex. On the left here, the one that looks kind of like a wedding cake is the one that I worked in. It's called the Eisenhower Executive Office Building, or the old Executive Office Building. Really cool building if you ever have a chance to go check it out. On the upper right is the new Executive Office Building. Not really as interesting to look at, but a lot of work gets done there, a lot of office space. And in the middle, there's this set of row houses along Jackson Place where most of CEQ is actually lodged. It's just the CEQ leadership team, which is in the old Executive Office Building, and then there are several row houses just across the street. And Wow, it's annoying that the spacing got a little off, and then there are all these components within the White House, right? The executive office of the president. This is not all of them. I just chose ones that had a role in environmental justice. It's made up of a number of policy councils: the National Economic Council, the Domestic Policy Council, the National Security Council, Council on Economic Advisors, CEQ, the Office of Technology Policy, the Office of Management and Budget. And then there's all slew of White House offices I didn't include, like the Office of Public Engagement, the Office of, I mean, it goes on and on and on. I, by the end, still didn't know what the charge of some of the offices were. And as I walk through some of these programs, you'll see these words, these names popping up again. But there's just it's a big infrastructure that the president directs in order to actually sort of get your hands around the federal government. So the first specific program I wanted to talk, or initiative flowing from that Executive Order 14008, was the establishment of the White House Environmental Justice Interagency Council. It's chaired by my former boss, Chair Mallory. The mission here was to coordinate across the federal government to develop a strategy to address current and historic environmental injustice. CQ was the administering body. There were 9 White House offices and 12 other departments and agencies that made up the council. And each member was directed to have an environmental justice officer within the department or agency that could be sort of the focal point, sort of a point of contact, and sort of leading environmental justice activities. Similar name, very different body, the White House Environmental Justice Advisory Council. It is made up of 24 environmental justice leaders from across the country, not federal officials. As this is a federal advisory committee, it's subject to the Federal Advisory Committee Act, which has a lot of procedural requirements that come along with it, but it was established so that the White House could receive recommendations from environmental justice leaders. Those recommendations came to CEQ and to Chair Mallory, but EPA did the actual administration of the Federal Advisory Committee, which is a big undertaking to make sure that all the procedures are being properly followed. Some of the recommendations that have come out recently are things like recommendations on carbon management and capture, on climate resilience, and then on a number of the programs, Justice 40, the Justice Scorecard, and the like. Justice 40. This was sort of the president's signature initiative to try to correct that history of neglecting some communities when it comes to federal benefits and investments. So the goal here was to provide 40% of the benefits of certain federal investments to disadvantaged communities. The executive order itself didn't define what disadvantaged communities are. The 7 program areas are in this graphic: climate change, clean energy, clean transportation, affordable housing, training and workforce development, remediation and reduction of legacy pollution, and clean water infrastructure. This program is administered by CEQ, Office of Management and Budget, and the Climate Policy Office. It currently includes 450 programs across 19 federal agencies that make covered investments. It doesn't mean all of their investments or all of their are going to disadvantaged communities, but these were the programs who the president charged with this goal of trying to deliver benefits, at least 40% of the benefits of their program to disadvantaged communities. In 2022, the White House released this number that as of May 23rd, about 14 months after the program began, $29 billion of funding opportunities had incorporated Justice 40 as a part of the funding opportunity. Here's some examples, make it a little more concrete. $500 million to electrify school buses, $1.3 billion to remediate and reduce pollution, $725 million to reclaim abandoned mine lands, and $36.1 million for technical assistance to underserved and veteran farmers, ranchers, and foresters. On the other side of the nice red line that our marketing people sent me as a template for a PowerPoint presentation, and so I used, is a picture of a very specific project close by. This is the Department of Transportation has a map of all of their Justice 40 programs. It's a $150 million investment for the Cross Bronx Expressway multimodal community connector. So I think it's the closest one to where we are today. DOT explains this project, and I will say I had never heard of this project until I looked on the map earlier this week. So I don't know much about it other than what I have read. But DOT explains this project as including dedicated bus lanes and bicycle pedestrian pathways, providing multimodal connections between the neighborhoods on both sides of the Bronx River. The project will reconnect communities between the Harlem River and Hutchinson River Parkway that were divided by the expressway and was constructed between 1948 and 1972. Part of a larger effort by DOT to reconnect communities that were divided by the development of the highway system, which largely were in communities of color, urban communities. And this is also a challenging example because as I was Googling around, I found a number of local environmental groups that were saying this isn't really an environmental justice project. This is a project where at least there are concerns that the local community wasn't sufficiently engaged and that it may increase traffic in those communities, increasing air pollution and water pollution. So that turns out is often the case. It's often messy, right? Often it is hard to figure out what indeed benefits communities, and certainly without talking with them. Here, I mean, I don't know any of the background. I only know what I read, but there was a fair bit of concern and some things that this funding will go to the state of New York for this project, and that New York cannot adequately address these concerns. Next, climate and economic justice screening tool. I've used the word disadvantaged communities a lot. I said the executive order didn't tell us what it meant, but the president did direct CEQ to develop a geospatial screening tool that can be used to identify communities that are overburdened and underserved. And that is, people call it the CGEST, environmental students. So you know that acronyms are the king of the field. This is version 1.0, sort of the national map. And the methodology here that CEQ developed was to identify census tracts that are in the 90th percentile for certain indicators of burden, and I'll talk a bit more about what those are in a moment, and that meet a socioeconomic threshold. Right. So if a community does both of those things, meets a socioeconomic threshold, because indicating that it is sort of a lower income community, and it experiences is in the 90th percentile for one of these indicators, then it lights up as gray on this map. And here's, I did not know exactly where we were when I hit the map, but I picked one White Plains disadvantaged community just so you could get some more granular understanding of how the tool works, right? A little hard to see, but I'll try to walk you through it. And so this tool draws on data that is at the census tract level, right? So it is can only incorporate data that is provided at that level. This census tract here lights up as a disadvantaged community for a series of reasons: housing costs, 91st percentile for housing costs, 97th percentile for lack of green space, 91st percentile for traffic proximity and volume, and then 94th percentile for low linguistic isolation, 96 for low median income, and then 96 for unemployment. And so as a result, you only need one to be identified as a disadvantaged community. This census tract has 6 of the indicators that come across that sort of light up. So those are what you might think of as the core environmental justice initiatives of the White House. But I wanted to talk briefly about a different context, the conservation context, and how some of the principles of environmental justice also animated the White House and the president's use of the Antiquities Act. And so the Antiquities Act enables the president to declare a national monument to conserve objects of historic or scientific interest. And if you look at these are the uses of the Antiquities Act that the President Biden has made, the number of them. And there are 3 themes that I think run through most of them. Honoring tribal nations and indigenous peoples by protecting sacred ancestral places, hearkening back to that commitment to the nation-to-nation responsibility I mentioned before, expanding access to nature for underserved communities, and telling a more complete story of our nation's history. Now, I said earlier I would come back to national monuments because this is the place where there is more question about the president's ability to easily rescind these monuments. Before the last Trump administration, there had never been a national monument that had been fully rescinded. It's a little bit more complicated than that, but I'll say that as sort of a first order. And indeed, the Department of Justice had issued a legal interpretation like the 20s saying that national monuments could not be rescinded because the statutory grant of authority to the president was to establish monuments. And the Department of Justice reasoned at the time that Congress was the entity that could then modify or disestablish monuments, and Congress has been very active in this space. President Trump, in his last term, substantially reduced the Bears Ears National Monument, the Grand Staircase Escalante National Monument, and made some management changes to Northeast Canyons and Seamounts National Monument. Litigation ensued. It was never resolved because before it could be resolved, President Biden took office and restored those monuments. So there are interesting legal questions that maybe we'll talk about if you're taking a public lands course about exactly what authority the president has here. It could be different than in the context of executive orders. So how do those themes play out? I'll talk about them briefly. First, these two monuments, Abaj Nuajo Itakukveni, ancestral footprints of the Grand Canyon National Monument in northern Arizona, and Aviquame in southern Nevada, really capture that spirit of listening to tribes and using the Antiquities Act to protect sacred lands to them. Sacred lands that include scientific and historic objects, but that of all of the significant scientific and historic objects that exist across federal lands, prioritizing the ones that also are sacred to tribes and that the tribes are asking for to have this form of protection. So Aviquame is a 500,000 acre national monument, as I mentioned, in southern Nevada. The camp, sort of the request to protect it was led by the Fort Mojave tribe, with support from the Moapa Band of Paiutes, the Las Vegas Paiute tribe, and the intertribal councils of Nevada and Arizona. Ancestral footprints, just going to call it that so that I don't have to stumble over the name every time, is a 900,000 acre national monument, sort of protects areas around Grand Canyon National Park. Now, these, and it was led, the request came from 7 tribes in northern Arizona and around that area, including the Havasupai tribe, which actually has its reservation in parts of the Grand Canyon. Now, some features here that were in some ways unique, a little bit tested out in the Obama administration when Bears Ears was first established, included having the proclamation be specific about directing the agencies to engage in consultation and collaborative approaches to management with the tribal nations whose sacred sites fall within the boundary. They also provide for ongoing access for tribal members to come into these lands for cultural, spiritual, and customary uses. They did some interesting things with establishing tribal commissions to help management and recognize that Indigenous knowledge could inform management decisions as appropriate. Now, in the Ancestral Footprints Monument, as in the others, the president recognized, in his words, that art history and conservation history is not it has a checkered past itself. And so he wrote, the history of the lands and resources in the Grand Canyon region tell a painful story about the forced removal and dispossession of tribal nations and indigenous peoples. The federal government used the establishment of Grand Canyon National Park to justify denying indigenous peoples access to their homelands, preventing them from engaging in traditional cultural religious practices within the boundary of the park. Despite these barriers, tribal nations and indigenous peoples persevered and continued to conduct their longstanding practices on sacred homelands just outside the boundaries of the national park, among the vast landscapes of plateaus, canyons, and tributaries of the Colorado River. So I highlight that because there is this notion, which I partially, maybe even largely ascribe to, that national parks are among America's greatest inventions. But we should not embrace that without recognizing the way in which the national park system was often developed as a form of exclusion for tribal nations. Second, two, reflecting this notion that establishing national monuments near nature deprived communities is of value are these: the San Gabriel Mountains expansion, Castner Range. San Gabriel Mountain National Monument was established by President Obama, but the area of national forest closest to Los Angeles was excluded. So President Biden expanded the monument by 100,000 acres to bring it right down to the foothills. And this is a picture that captures some of that. And then Castner Range on the other side is a 6,600 acre national monument, very close to the downtown El Paso, Texas. It's been closed to the public since the 1940s. The name Castner Range, from the picture, you might think that means mountains. It's actually about missiles. It was a military ordnance testing area, which is why the public has not been there. But it's no longer used for that purpose, and DoD has begun to remediate it and make it safe for public access. And so this monument will provide public access right near the heart of urban El Paso, Texas. And the president acknowledged that in his proclamation, saying, once it is safe for public access following remediation of military munitions and munitions constituents, Castner Range will become a natural classroom offering unique opportunities to experience, explore, and learn from nature in a unique setting that is close to a major urban area. Access to nature is particularly important for underserved communities like those bordering Castner Range that have historically had less access to our public lands. I took out the last slide. Well, I'll just mention the last two monuments because apparently I deleted the slide, which are small civil rights monuments, but also very important ones. The Emmett Till National Monument, which has sites in Mississippi and Illinois, and the Springfield Race Riots National Monument, which protects some archaeological sites in Springfield, where a race riot in 1908 decimated the African-American community as well as others. In the Till Proclamation, the president wrote, "These places contain historic objects that illuminate the complicated fabric of our nation and the injustice and inequality that Black people continue to experience today. They are places where we can learn about and reflect on the specific painful events that ended Emmett Till's life and larger history of Black oppression, resistance, and resilience, which ultimately culminated in a movement that bent our nation's laws towards justice." So I will stop there. I've tried to capture many of the environmental justice initiatives at the White House. Certainly not all. I'm happy to answer questions about other things that you've heard about as best as I can. Thank you.
So we have time for a few questions.
I was gonna say, you have a better arm than me if you think you can hit that.
Professor, good evening. Thanks for your time. I was wondering if at your time at the CEQ, did you come across any of the statutory boundaries of your authority and your resourcing to do the work that you need to do, and would recommend any changes that were expansion to the NEPA?
Well, when we started on the resource front, CEQ is a weird entity, like all White House offices. I think there were 9 employees when I entered. So there's 9 permanent career employees at CEQ. And we were trying to assemble a team to take care of all this work with very little money. But halfway through the term, the Inflation Reduction Act was passed, and we got $60 million. Which CEQ's annual appropriation is usually about $1.5 million. So there's a number of things that are being done with that money, but that dramatically changed the scale of the work that we were able to do and the resources we were able to bring to bear. Now that money is, I mean, even if IRA is not rescinded, which I think anyone's question, it's only 4-year money. So it is an odd, I mean, it's like how we built something with this money without any ability to have longevity was a trick. So for example, I had had interesting conversations with law professors elsewhere. Indeed, and in fact, I think including Sharmila Murthy, who was here, you said at some point recently, where I would say, we would love to bring you in. I can pay you for 4 years. After that, we don't have any money. So like these weird term appointments, which are very unusual. So that's having a more steady resource base to do the work. Certainly something that I think I would advocate for. Not in the immediate future. It's very likely CEQ's budget will be dramatically reduced, I think, in the coming years. On the legal side, I don't know that. I mean, there's lots of bills in Congress around environmental justice that have been kicked around. The problems are really hard problems, right? One of the challenges we didn't talk about is how should federal agencies think about cumulative impacts, like the meaning, like when turns out we're not generally exposed to one chemical at a time or one stressor, right? We're exposed to a whole suite of chemical and non-chemical stressors which affect our health outcomes. But it's really hard to figure out. EPA has been doing a lot of work to try to figure out how to tackle and even analyze cumulative impacts. They've done some great work on that. How you then translate cumulative impacts analysis into policy and law will be the next challenge. At the moment, there's sort of some placeholders out there saying, if you have good science on cumulative impacts, you should be thinking about it. And some of the bills, like the Environmental Justice for All Act, were intended to try to get at that cumulative impacts question. Great, thanks for the question.
Hi, thanks for your speech. It was really good. I went to Louisiana State University for undergrad, and there's a stretch of land between Baton Rouge and New Orleans that's referred to as Cancer Alley, where the incidence of cancer among the residents is really, really, really high. And those are mostly disadvantaged communities. So I was curious if you had any initiatives like during your time working like with the White House and all this through environmental justice, and if not, like how you would go about an initiative like for that specific area.
Yeah, I mean, we met with community leaders from Cancer Alley pretty regularly. I believe there's someone on the WEJAC, the White House Environmental Justice Advisory Council, who is a leader of an organization down there. So something we were very attentive to. Obviously, one facet of that is figure out what resources on the positive side can be deployed, whether it's to remediate pollution, install fence line monitors. And I think the Justice 40 framework was really intended not just for Cancer Alley, but more broadly. And then on the sort of the regulatory side, I didn't talk much about all of the regulations that all of the agencies were doing, but EPA engaged in a number of hazardous air pollution regulations to try to ratchet down on the amount of emissions that are impacting communities like Cancer Alley. We also heard from, and this was very, we heard mixed things from multiple directions from EJ leaders about whether the federal government should come up with resources to move people in parts of Cancer Alley out. And community leaders were very conflicted about it. There's not clear legal authority to do that. It's not obvious what money we would come up with, but it's the kind of thing that we spend a lot of time thinking about, trying to figure out how both to listen to the communities and respond to this sense from some people that it was just unlivable.
Thank you.
Hello, back here, like way back here. So I'm sorry to put you in this sort of position, but given the results of this morning and last night, not just necessarily with the presidential election, but also like the legislative results potentially with the House, and then in the first Trump term, the Supreme Court, the judicial appointments. I care deeply about a lot of this stuff, but I just don't feel promising about it going into the future and going like for the next generations, especially with the court, the top court, like the survival of a lot of these things, not just the funding, but like so forth. And I guess like you were inside this, at least, during more positive administrations for this sort of issue, but like, is there, I guess there's always hope, but like, is there, you know, you know,
I gave you my first order answer, which was yes.
I know.
Because we can redo it. But on the legal side, I'll pick up on that briefly. I noted in passing the way that the President Biden's environmental justice executive order was effectively race neutral. I won't go through all the reasons that that was done. I will tell you that if you look at the way that we pursued environmental justice, it was sensitive to the fact that as a matter of data, communities of color are often disproportionately burdened. But rather than focusing on demographics, we tried to focus on the burdens. Right? We don't need to make, or this is our theory. We don't need to look at race if we can get good data on where the burdens are, because if a community is overburdened, we should be addressing it, regardless of whether it's a white community, a brown community, a black community. Now, based on, as I said, on the facts, we know that more of those communities are communities of color, but not all, right? So I actually think that is the right approach, right? I think it aligns with its pragmatic approach, given what you said about the courts, right? I mean, no one has fought that particular fight, but it's not a fight I would want to have in the current courts. And I think if we're talking about how you make environmental justice, maybe this might be overly optimistic, something that we can all embrace, that's the way you get there. You get there by saying, look, this isn't about who you are. It's about the burdens that your communities face. And there's a lot of West Virginia mining towns, which also are disadvantaged communities under the Climate and Economic Justice Screening Tool. And we thought a lot about how to try to create something. Now, as I said, it will go away, but it could come back. And I do think that it points a direction that from the federal government's perspective, I will say that is not a satisfying answer to a lot of EJ activists. We took a lot of heat for not having the Climate and Economic Justice Screening Tool incorporating racial demographics, because understandably, like, communities of color were like, this is racism and you are not accounting for that sufficiently. And I hear that. I think we can get to a place, this was our theory of the case, where we're focused on the lived experience of communities in a fashion that may be easier to have more durability when we have the chance to do it again.
Time for one more question.
Thank you. So as I learned on Wednesdays during this time, national monuments are intended to promote some sort of goal. Well, yes, I'll say that. So like whether the goal is like scenic, and so like they have like some kind of like management, I guess, set out to like proliferate that goal or support it, but then still people will like litter, right? For example, or there'll be the goal of like memorializing like a racist time in history where like Jim Crow was like legalized, and so you have like the Emmett Till like national monument, but then like people will like desecrate it, right? And so there seems to be like this like dissonance between like the goal that the government is trying to like promote, and then like this difficulty of the public to play their part and steward that goal. And so I'm curious, like, what do you think informs that gap, and what role do you think education, I'm leading you, education would play in like ameliorating this this gap?
Yeah.
Is my question.
That's a great question. I mean, it is a challenge that there are not enough money in the program often to engage in all the management you would like. I do think that when we designate something as a national monument, it does create an attention to the space that is educational in and of itself. And the way the Park Service interprets it and BLM interprets it furthers that. This is orthogonal, but I think relevant. One of the things we talked about with Emmett Till, there's a sign that commemorates the place where people think Emmett Till's body was found. And it's been destroyed multiple times. One version of what we could have done is say, well, let's build a new sign and we'll police it. We actually thought it was important to try to preserve that history too, the history of the desecration, because that is part of the story. And I mean, it's an imperfect solution, but I do think that when we reflect on the history of something like Emmett Till, the way that society and people receive that over time is part of the story that's important to highlight, because we need to face the painful, shameful parts of our history if we're going to get beyond them. At least I think that's my belief, and I think that is the theory that underlies these monuments. And obviously, how it unfolds, I don't know that we know yet.
Thank you all for attending, and let's give a big round of applause. We're going to conclude our annual Kerlin lecture. I would now invite you all to attend a reception in the tutor room. I know graduate students love free food, so I please encourage you to go across the way, enjoy the nice weather, and the inside of the tutor. Thank you very much.